Hey guys, James Abrenio coming to you from Abrenio Law, your Northern Virginia personal injury criminal defense law firm. Today I wanted to do a quick short video about a recent opinion that I just learned about from Virginia Lawyers Weekly, which is a great publication. It's essentially a trade manual or a trade publication for lawyers here in Virginia. But a recent case came down that was very instructive, and it was written up on Virginia Lawyers Weekly. The case is Rose versus Commonwealth. And this looks like it's coming out of the Circuit Court of Dinwiddie County, which was appealed. And it's instructive as to give us guidance as to what constitutes felony child abuse here in Virginia. And the code section we're talking about is 18.2-371.1 subsection B. And so that section provides that, quote, any parent, guardian, or other person responsible for the care of a child under the age of 18 whose willful act or omission in the care of child such was so gross, wanton, and culpable as to show a reckless disregard for human life is guilty of a Class 6 felony. So, end quote. So that essentially talks about behavior that when you have a child in your care, what essentially behavior can constitute felony child abuse, which a felony is it's a game changer for purposes of employment, for your life. You lose a lot of civil liberties if you have a felony conviction. So and the case didn't talk about jail time. It didn't talk about a sentence. So I'm not aware of that. But if you have a felony conviction, your record has real consequences. So in this case, it dealt with reckless driving and essentially caring for children while driving. So the write-up essentially states that the defendant or appellant at this point, after having consumed alcohol, and it's not very clear, so I imagine the record's not quite clear about how much alcohol the defendant had, but after that, she put 4 children in her car without a child seat's restraints, and the allegations are lost control of the car on a curb while attempting to use her cell phone, hit trees, rolled the car twice, and injured children. The circuit court convicted her, and that was ultimately appealed. And that appeal conviction was affirmed. So essentially, the Court of Appeals, I believe, from this article, is saying, look, the trial court was correct in convicting this person of a felony child abuse. Now, when you look at that behavior and you think about, well, what is wanton and willful action that is such gross and wanton and culpable as to show disregard for the human life. Even as a defense attorney, I'm looking in that case and I'm thinking, well, that's a tall order to convince a judge or a jury to acquit you on a felony conviction when you have all those factors: the alcohol, the lack of use of child seats, the multiple children involved, using a cell phone while you're on a curb. I do plaintiff's work as well. And sometimes you're going to argue, look, accident happens. And there are many cases where a car accident is really just a civil matter, negligent behavior, and things just happen. But I think on this level of behavior, it's easy to see why an appellate court would affirm this conviction. And just from a procedural standpoint, when you're appealing a conviction from a trial court, you're using the concept of whether or not there was sufficient evidence to support the trial court or the fact finder's decision. So when you're appealing that kind of factual decision by a court, you're already on difficult footing, because they're essentially giving deference for the trial court. And that deference makes sense, because a trial court has the opportunity to actually see witnesses, hear testimony, observe behavior, hear tone of voice, and see the actual trial itself. So they're going to give deference to factual findings to a trial court. So yes, I can understand why the court writes why the appellate court reached that decision, but I also can understand why a trial court reached that opinion. So look, if you're charged with a felony child abuse, this is the kinds of analysis that you'll be looking at, and the court will be looking at. They're going to be looking at the facts to determine what is so gross, wanton, and culpable to show disregard for human life. Now, 18.2-371.1 has other behavior that could be considered felony child neglect, but we're talking about a very specific factual case here, so that's what we're focused on. I would urge you to Google that statute if you're curious about what the totality of the statute says. But what this just reminds you is think about as you're living your life, whenever you're caring for children, even if they're your own children, you obviously have a duty to them. You have a duty to protect them. You have a duty to ensure their safety and do what you can to protect them. But you also have a duty not to behave, criminally. And I can understand why behavior like this is seen as a criminal act. You cannot have people caring for children drinking alcohol, then putting kids in cars without car seats, and then also having a cell phone used at the same time. To me, that is pretty egregious behavior. And again, I can certainly understand why a trial court would uphold a conviction. So hopefully this was useful in getting a better understanding of our felony child abuse cases and statutes here. And if you find this video useful, feel free to comment. Make sure that you're subscribing to this channel. Like I said, I'm going to do my best to, as I see cases to come down the pike, to give little snippets of my thoughts. And of course, if you have questions, you can reach out. So wish you guys the best. And feel free to reach out. Phone number 703-570-4180. But definitely like that subscribe button, subscribe to this channel. Thanks a lot, guys. Until we chat again, stay safe. Bye.